Be ready. 5 seconds to go. Start. Now, the question that begs consideration in the light of the submissions advanced across the bar is whether the principles of natural justice were observed in compliance or not, as stated here in above Rule 81 of Rule 1976, does prescribe observance of the principles of natural justice. From a close scrutiny of the inquiry report dated 29/10/1993, it transpires that the inquiry officer has found the petitioner guilty on the basis of the reply to the charge sheet submitted by the petitioner and other documents, but not a single witness was examined by the inquiry officer in the presence of the petitioner, and also no date, time, and place was fixed by the inquiry officer. It is not discernible from the inquiry report that the petitioner was never granted any opportunity of personal hearing or cross-examine the witnesses, and in the circumstances there appears to be non-compliance of Regulation 81A of the 1976 rules, which enjoins due observance of the principles of natural justice. In this connection, Article 14 of the Constitution of India may also be referred, which clearly postulates that authority competent to pass orders is required to record regions, which is one of the principles of natural justice governing exercise of power by the administrative authority. It is well enunciated in various decisions of the High Court and the Apex Court that the disciplinary authority has to apply his mind to the record apart from the finding recorded by the inquiry officer before coming to the conclusion whether the charge of misconduct has been proved against the delinquent. Merely asking the petitioner to submit an explanation, in my opinion, is not sufficient where it is proposed to impose a major punishment. There are two kinds of hearings: a personal hearing and second, non-personal hearing. When it is proposed to impose a minor punishment such as withholding of increments or a fine or warning, a non-personal hearing would suffice. In a non-personal hearing, all that has been done is that the delinquent employee is issued a show cause notice to which he gives a written reply, and on that reply the punishment is straightway imposed, giving reasons. In such a case, it is not necessary to hold a full-fledged oral inquiry, giving the concerned employee an opportunity of producing his witnesses and cross-examining the witnesses against him. However, when it is proposed to impose a major punishment like dismissal, ordinarily a full-fledged inquiry must be held. This is because a major punishment not only has very serious consequences upon the employee, but would adversely affect the family. Hence, the law imposes a stricter and elaborate procedure requiring a full-fledged oral inquiry in cases of major punishment. In such cases, it is ordinarily necessary for the employer to issue a notice to the employee indicating the date, time, and place of the inquiry after appointing an inquiry officer. On the date and time fixed, the witnesses against the concerned employee is required to be examined ordinarily in his presence, and he must be given an opportunity to cross-examine them. It is a great honor and privilege to participate in the fourth convocation of the Indian Law Institute. The stars of the convocation today are indeed the graduating students. So I would like to take special privilege in congratulating all the students present over here with a special word of congratulations to those who have received the medals. I would also like to extend my greetings to the proud parents who will ever cherish the memories of this day with much greater fondness than the students. I'm happy to note that the Indian Law Institute is empowering the young minds with the socially relevant legal education, skill, and ability, and inculcates in them the values of professionalism. It is my privilege to address such an august gathering present here, comprising a rich group of academicians and scholars. The scholars will be going out into the world with one of the most valued degrees in the world. It is because the Indian Law Institute has the unique character and distinction of being a convergence of the three branches of government: the executive, the legislature, and the judiciary. The Indian Law Institute is a signature on the road of the legal education whose origins were enriched by the inaugural function blessed by none other than the first President of India in the gracious presence of the first Prime Minister of India and the Honorable Chief Justice of India. Since its momentous birth in 1956, the Institute has been amongst the leading centers of legal research in our country. The deemed university status has further augmented its profile manifold. Pandit Nehru's wishes on the event are recalled at the Institute as cherished memories of a stirring tribute and recognition of the men and women of the law. He had envisioned the Institute as an instrument to make an invaluable contribution to the advancement of a modern welfare state.